right, welcome everyone. Welcome to Understanding the Basics of Pennsylvania's Carbon Sequestration Law. My name is Audry Thompson, and I'm a staff attorney here with the Penn State Center for Agricultural and Shale Law. The Understanding Agricultural Law educational series is a course designed to provide subject matter literacy and competence on fundamental issues of agricultural law to attorneys and business advisors who work with or represent agricultural or rural clients, but who may not necessarily specialize in agricultural law. This series is wholly sponsored by the Pennsylvania Department of Agriculture's Ag Business Development Center, established through the 2019 Pennsylvania Farm Bill. The Ag Business Development Center aims to enhance the long-term vitality of Pennsylvania farms by supporting farm transitions, both from generation to generation and from conventional to organic farming, supporting beginning farmers, providing risk management education, and providing financial assistance through low-interest loans and grants. And as you can see right here on this slide, we've covered numerous topics so far, including ag cooperatives, finance in the farm credit system, crop insurance, conservation programs, ag labor, Pennsylvania's Clean and Green program, water issues, and many, many more. You can find the materials and recordings from all of these webinars on our Understanding Agricultural Law landing page on our website at aglaw.psu.edu. Next slide. Upcoming topics in our Understanding Agricultural Law series for 2025 include pesticide drift, that's going to be on February 28th. We've got the Clean Water Act and Ag Impaired Waters and TMDL process, that's going to be on March 24th. And then Pennsylvania agricultural exemptions for inheritance tax and other real estate transfers will be on April 25th. We also run our quarterly dairy legal webinar series, which covers the legal and regulatory developments of the U.S. dairy industry. That includes an in-depth look at a single focus topic. That on February 18th this month, we're going to do highly pathogenic avian influenza in dairy cattle, regulatory measures so far. And then on April 15th, we're going to do bovine disease controls, federal and Pennsylvania laws and regulations. And then I will tell you verbally, we don't have this set up. I'll back up. Everything on this screen is set up for registration. You can register for it right now. But in July, if you are active in the dairy industry in any fashion, you know that the federal milk marketing order rule was just issued recently. We're going to do the federal milk marketing order, that final rule that was just issued. We're going to cover that in July. So mark a calendar for all of that, and then look forward to more on the federal milk marketing order in July from us. Next slide, please. And just a few reminders before I turn this webinar over. We are recording this. If you have any questions, please write them in the Q&A feature. I will collect them and ask them at the end. We encourage you to fill out the poll survey at the end of the webinar. Please tell us what you liked, where we can improve, and what topics you'd like to see in the future. And if you would like for us to submit this program for free CLE to the Pennsylvania CLE board, or we can send you an attendance certificate that you can submit to your state CLE board. We're going to post a link in the chat. That link might actually already be there. You need to fill out that form to get your credits for the CLE. As part of our responsibility to ensure attendance, there's a code word that we're going to provide throughout this webinar. You're going to have to enter that code word into the form to get your credit there. If you are on the phone, it's always difficult for me to see. Let's see attendees. I don't see anybody on the phone, but if you're on the phone, send me an email at aet17@psu.edu. That's Alpha Echo Tango, aet17@psu.edu, and I will send you a link to that form. Also, just if you are a Pennsylvania attorney submitting for CLE, we submit that directly to Pennsylvania. So you don't need a separate attendance certificate. Some people check that box, and I'm always wondering if they really do need that. But you don't have to do anything. We send it right in, and we pay for it too. So, all right, I will now turn this webinar over to Chloe Marie. Chloe is a research specialist at the Penn State Center for Agricultural and Shale Law. She holds a Bachelor of Law and Master of Law degrees from the University of Paris-Saclay in France, and an LLM from Penn State Dickinson Law with a focus on energy and natural resources. She's a principal contributor to and manager of the Center's issue trackers and virtual resource rooms, which include compilations on underground injection control well regulations, oil and gas development on federal land, and interesting, natural gas pipelines. There's a little typo here in my script. Natural gas pipelines. So Chloe, the screen's all yours. Tell us about Pennsylvania's carbon sequestration law.
Thank you, Audrey, and welcome everyone to today's webinar on the basics of recently adopted Pennsylvania's carbon capture and sequestration law. So whenever we burn fossil fuels, for example, such as coal, oil, or natural gas, the combustion releases our carbon dioxide, CO2, into the atmosphere. So CO2 is a major source of greenhouse gas emissions, particularly in the industrial sector, and the growing need to reduce these emissions has led to a significant increase in the development and implementation of carbon capture and storage technology in recent years. Carbon capture and storage technology involves capturing carbon dioxide emissions from sources such as power plants and industrial processes. This captured CO2 is then transported and stored on the ground in geological formations, preventing its release into the atmosphere. So a few states have already adopted legislation to support the development of carbon capture, utilization, and sequestration projects, with Pennsylvania recently joining them following Governor Josh Shapiro's signing of Senate Bill 831 into law, now Act 87 of 2024, known as the Carbon Capture and Sequestration Act, allowing for the underground storage of carbon dioxide in the state. So in this presentation, we will provide an overview of CCS technology, focusing on how it captures, transports, and stores carbon dioxide. We will also cover the federal regulations that govern those projects. And next, we will explore Pennsylvania's potential for carbon capture and storage, and discuss the law's major provisions, including the ownership and transfer of pore space and permitting and operating procedures. Additionally, we will explore related legal issues such as property rights, ownership disputes, and potential liabilities associated with carbon dioxide storage. But just to give you a quick overview and understanding of why the carbon capture and storage technology is getting so much attention in recent years, it seems that this technology could be the solution to a lot of our greenhouse gas emission reduction issue. The International Energy Agency highlights that carbon capture and storage plays an important role in achieving net zero by 2050, and that it is key to reducing carbon emission from existing energy infrastructure, such as power plants and industrial facilities. And CCS is especially valuable for hard-to-abate sectors such as cement and steel. It also supports the scalable and cost-effective production of low-carbon hydrogen production, and plays a vital role in carbon removal strategies, including bioenergy and direct air capture. So this graph here shows the global capture of CO2 by source in the International Energy Agency net zero emissions scenario from 2020 to 2050. The total amount of CO2 captured increases significantly, rising from almost zero in 2020 to about 8 gigatons by 2050. We notice shifting trends where over time, the reliance on fossil fuels such as coal and natural gas decreases, while bioenergy and direct air capture become more important. According to the IEA, this growth reflects the need for strong policy support, technological innovation, and investment in CO2 capture infrastructure to achieve that 2050 goal of net zero emissions. So in its 2023 update to the net zero roadmap, the IEA pointed out that if the planned CO2 capture capacity is fully implemented and the current growth continues, global capacity could meet the levels needed for net zero emission by 2030. However, to make this a reality, it suggests it is important to shorten project timelines, especially when it comes to developing CO2 storage. And before we explore further, let's first take a look briefly at the technology itself and how it actually works. So the process of carbon capture and storage technology involves three main stages: capture, transport, and storage. In the capture stage, when facilities such as refineries or power plants burn fossil fuels, they produce carbon dioxide. Typically, the CO2 would be released directly into the air through a smokestack. However, in facilities with carbon capture technology, the CO2 is funneled through a special system built into the ventilation. This system captures the CO2 before it can escape into the atmosphere. So there are three main methods of capturing CO2. We have post-combustion, which is commonly used in existing plants. We have pre-combustion, where CO2 is captured before the fuel is burned, and oxy-fuel combustion, where fuel is burned in pure oxygen. Now, in the transport stage, once the CO2 is captured, it is usually transported via pipelines or trucks to centralized storage hubs. Some facilities may use temporary on-site storage tanks, but pipelines are generally the most common way to move carbon dioxide to its storage sites. And finally, in the storage stage, the captured CO2 is stored permanently on the ground in geological formations to prevent it from reaching the atmosphere. These formations include deep saline reservoirs, depleted oil and gas fields, or unminable coal beds. These areas consist of porous rock layers, which are capped by non-porous rock, effectively trapping the CO2 on the ground. As of September 2023, there were 15 operational carbon capture and storage facilities in the United States, according to the Congressional Budget Office. These facilities are primarily located at natural gas, ethanol, and ammonia plants. Together, they capture about 22 million metric tons of CO2 annually, which is only 0.4% of the country's total annual CO2 emissions. Most of the captured CO2 is sold to oil companies for what they call enhanced oil recovery. In this process, CO2 is injected into partially depleted oil wells, increasing pressure to push more oil to the surface. This method not only extracts additional oil, but also traps CO2 on the ground. And this approach is pretty common, but it puts the focus more on making money for the capturing facilities than on permanently storing CO2. And also came across this interactive map from the Clean Air Task Force. I think it is a great way to see how carbon capture and storage projects are spread out across the United States. It highlights key locations, showing a concentration of activities in the Midwest and Gulf Coast regions. Different subsectors involved in CCS are marked with colored dots and geological formations suitable for CO2 storage or shaded in gray. You will also notice large dots in these regions, which indicate that significant storage capacity is being planned or built alongside CCS projects. If you look closely, some circles have thicker borders. These represent operational projects. That's a sign that CCS technology is already being put to use in several locations, suggesting that CCS technology is moving beyond the development phase in certain locations. And what's worth mentioning, and this comes from the Congressional Budget Office report, is that the high cost of CCS is one of the main challenges to making it more widely used. For many industries, the expense outweighs the financial and environmental benefits. For example, facilities like ethanol or natural gas processing plants have relatively pure CO2 streams, making capture cheaper. On the other hand, power plants and industrial facilities emit mixed gases, requiring more complex and expensive technologies to separate and capture carbon dioxide. And also the cost does not end with capture. Getting CO2 to storage sites, usually through pipelines or trucks, adds more expenses. And while things like enhanced oil recovery and federal tax credits offer some financial help, they are often not enough to cover all the costs. And because of this, carbon capture and storage adoption is still limited, especially in industries with high emissions. Now looking at federal regulations. The U.S. Environmental Protection Agency, EPA, regulates the injection of fluids into the ground to protect drinking water sources through the Underground Injection Control Program, UIC, of the Safe Drinking Water Act. For the specific purpose of CO2 storage, the EPA enforces regulations for Class 6 wells, which are specifically designed for the geologic sequestration of CO2. And entities wishing to store CO2 underground must obtain a Class 6 permit to ensure compliance with these protective measures. Class 6 wells differ from Class 2 wells used for CO2 enhanced oil recovery operations. The underground injection of CO2 for enhanced oil recovery has been a long-standing practice. However, CO2 injection for geologic sequestration presents distinct technical challenges involving much larger volumes of CO2 and larger scale projects compared to previous practices. So the EPA has set specific requirements for Class 6 wells to ensure carbon dioxide is stored safely and effectively. So first, the area must have the right geology to store CO2 without risk. The area must be free of faults, fractures, and risks of seismic activity. Additionally, models must predict how far the CO2 will spread and address any issues with existing wells. The wells themselves must be built to prevent leaks and designed to last the entire project, which can be lengthy, using corrosion-resistant materials suited to the site conditions. And throughout the project, the integrity of the wells, groundwater quality, and the movement of CO2 must be monitored even after injection ends until the EPA determines that further monitoring is not necessary. So the injection process must also ensure that drinking water sources and human health are protected. And at the end of the project, the injection well must be properly sealed to prevent any fluid movement that could harm water sources. Operators must also prove that they have the financial resources to cover corrective actions, well plugging, post-injection care, and emergency responses. They are required to have a site-specific emergency response plan and must report all testing and monitoring results to the EPA to ensure compliance with regulations. Operators must also submit a permit application to build and operate the well, and if a state has EPA-approved authority known as primacy under the UIC program, that state handles the permitting process. However, if the state lacks primacy, like Pennsylvania, the EPA takes over responsibility for managing the UIC program and issuing the permit directly. So now let's take a look at the financial incentives and programs, as well as research and development support that are helping drive carbon capture and storage forward. So the Federal tax credits for carbon sequestration got their start in 2008 with the Energy Improvement and Extension Act, which added Section 45Q to the Internal Revenue Code. So this section introduced tax credits for CO2 that is securely stored on the ground or used in enhanced oil recovery with safe storage. Since then, the program has been expanded and updated to offer even more support for carbon capture projects. In 2022, the Inflation Reduction Act made significant changes to Section 45Q by increasing tax credit rates and extending deadlines. However, to unlock the full value of these credits, projects need to meet certain labor standards, such as paying workers a prevailing wage and following registered apprenticeship requirements. So the Inflation Reduction Act raised the tax credit from $17 to $85 per ton of CO2 for industrial and power generation facilities. And starting in 2027, these amounts will also be adjusted for inflation. So operators now have until January 1st, 2033 to begin construction to qualify for the tax credits. Industrial and power facilities must capture a minimum amount of CO2 annually to qualify, at least 12,500 metric tons of CO2 per year. And facilities that start construction before January 2033 are eligible to claim the tax for up to 12 years once they become operational. Then under Title 17 Innovative Energy Loan Guarantee Program, the U.S. Department of Energy Loan Programs Office provides up to $8.5 billion in loan guarantees to support large-scale carbon capture, utilization, and storage projects. The program focuses on advancing technologies that significantly reduce greenhouse gas emissions or air pollutants. This includes projects at power plants or industrial facilities that capture and store carbon dioxide underground or repurpose it. It can also fund infrastructure such as pipelines for transporting captured CO2 for storage or reuse. So a Title 17 loan can cover up to 80% of eligible project costs, though costs associated with research, development, and demonstration of new technology are not covered. And to qualify for funding, projects must meet specific conditions. The project must be based in the US, and activities must involve energy production, consumption, transportation, storage, or manufacturing, or support decarbonization efforts. Additionally, the project must demonstrate significant environmental benefits by reducing, avoiding, using, or storing greenhouse gas emissions or air pollutants. And applicants also must show they have a reasonable ability to repay the loan. The technology involved must also be proven and commercially ready with data to support performance. And projects that are purely in the research or pilot stages do not qualify for this funding. Now, in terms of funding research, since the late 90s, the US Department of Energy has invested billions into carbon capture and storage initiatives. And in 2021, the bipartisan infrastructure law allocated $8.5 billion to support CCS projects, including the construction of new carbon capture and storage facilities. To oversee and select eligible projects, the DOE established the Office of Clean Energy Demonstrations, which focuses on advancing decarbonization efforts. The OCED manages two key programs, the Carbon Capture Demonstration Projects Program and the Carbon Capture Large-Scale Pilots, both focus on advancing carbon capture technologies. So the Carbon Capture Demonstration Projects Program focuses on projects that are ready to move beyond testing and into full-scale commercial operation. These projects are expected to be close to or at full commercial deployment, typically at an operational facility like a power plant or large industrial facility. On the other end, the Carbon Capture Large-Scale Pilots Program supports earlier stage efforts compared to the demonstration program. It funds projects that are not yet at full commercial scale, but are testing carbon capture technologies at a large scale for the first time. And in 2023, the OCED allocated $1.7 billion to fund about 6 CCS demonstration projects, covering up to 50% of their costs. They also provided up to $820 million for up to 10 pilot projects with the federal government covering up to 70% of the expenses. And more recently, in December 2024, the OCED announced up to $1.3 billion in funding for approximately 10 CCS projects, with the federal government covering between 50% and 80% of the cost, depending on the project area. And the funding will be allocated across 3 main areas. First, up to $750 million for large-scale demonstration projects at 1 coal-fired power plant and 2 industrial facilities. Second, up to $450 million for pilot projects testing new carbon capture technologies. And third, up to $100 million for planning and designing shared CO2 transport and storage infrastructure. So the deadline for final submissions is July 1st, 2025, with awards expected between November 2025 and March 2026. So now looking at Pennsylvania's potential for carbon capture and storage, a recent 2024 report from the Clean Air Task Force using available government data highlighted that Pennsylvania ranked 4th in US carbon emissions in 2021, with over half of these emissions coming from the power and industrial sectors. In 2022, the state's industrial sector alone emitted nearly 25 million metric tons of CO2. Of this, around 25% came from metals productions, 20% from the minerals sector, and just over 49% from industries such as natural gas processing, chemicals, and petroleum refining. The report also revealed that Pennsylvania has underground formations in its western, central, and northern regions that could potentially store CO2. These formations include saline aquifers, which are layers of saltwater-filled rock capable of holding CO2. Experts estimate that experts estimate these aquifers could store 2.4 billion metric tons of CO2, according to the Pennsylvania Geological Survey, with the U.S. Department of Energy providing an estimate of 17.34 billion metric tons, enough to store all of the state's annual CO2 emissions, about 100 million metric tons from all sectors for over 170 years, according to the report. Now the most promising CO2 storage formations in the state are the Lockport and Knox formations, located primarily in the western and central regions of the state. with estimated combined storage capacities ranging from 510 million to 1.64 billion metric tons. Other formations such as Onondaga, Oriskani, and Medina show less potential, while Bass Islands has no measurable capacity based on available data. However, many of these formations have low permeability, which can make CO2 injection at commercially viable rates difficult. And data limitations are also a barrier, and further studies will be needed to fully determine the viability of these formations for larger scale CO2 storage. The report also mentioned that depleted oil and gas fields in Pennsylvania may provide another storage option. So while data on these fields is more widely available, the high density of abandoned wells in these areas increases the risk of CO2 leakage, making secure storage more challenging. Now, Marcellus and Utica shale formations might also serve as storage sites, but further testing is required to evaluate their potential. And finally, the report noted that many potential CO2 emitters in Pennsylvania, 109 45Q eligible facilities emitting more than 50 million metric tons of CO2, are located in the eastern parts of the state, where the geology is not so suitable for storage. So CO2 pipelines will likely be needed to transport captured CO2 to storage sites. However, the recent expansion of the Section 45Q tax credit to an additional 140 facilities across the state might improve the carbon capture, transportation, and storage potential across Pennsylvania. Now, on July 17, 2024, Pennsylvania passed the Carbon Capture and Sequestration Act, a bill introduced by State Senator Gene Yaw. Senator Yaw called the legislation a significant step forward in reducing emissions without compromising the state's energy grid. Senator Yaw also highlighted that the law opens up opportunity for Pennsylvania to tap into billions of dollars in federal carbon capture funds, which could bring long-term investment and economic growth to the state. Now, another reason often highlighted for advancing carbon capture and storage in Pennsylvania is the opportunity to develop clean hydrogen hubs right here in the state, working together with other neighboring states and private companies. So these hubs plan to produce hydrogen by combining methane gas with heat and steam. But to qualify as clean hydrogen, the CO2 released in the process must be captured and stored. To give you some context, the 2021 Bipartisan Infrastructure Law created a program, the Regional Clean Hydrogen Hubs Program, to support the development of hydrogen hubs across the United States. And the U.S. Department of Energy's Office of Clean Energy Demonstrations is leading the charge to select these networks and promote hydrogen as a clean energy source. So the OCED has already awarded $30 million to the Appalachian Hydrogen Hub to kick off its first phase. So this phase focuses on planning, designing, and engaging with communities and labor groups. This grant is part of a larger federal cost share of up to $925 million for the entire project, which spans West Virginia, Ohio, and Pennsylvania. And more recently, on January 17, 2025, the OCED awarded $18.8 million to the Mid-Atlantic Hydrogen Hub, this time a partnership between Delaware, New Jersey, and Pennsylvania for phase one. And this is part of a total federal cost share of up to $750 million. So supporters of the legislation argue that establishing a regulatory framework for developing carbon storage facilities not only lays the groundwork for producing clean hydrogen, but also attracts more federal funding and investment to the state. They believe this will lead to increased job creation and economic opportunities for Pennsylvania. On the flip side, opponents of the legislation argued that billions of dollars have already been spent on carbon capture and storage demonstration projects without any real success. While carbon capture and storage has been used for enhanced oil recovery, they pointed out that the main goal of EOR was never to store CO2, and there are still big uncertainties about how to adapt it for permanent storage. They were also concerned that the legislation will take away Pennsylvania landowners' subsurface property rights, shift liability to the state, and put communities at risk by introducing potentially dangerous fossil fuel infrastructure. So now back to the act itself. It is made up of 12 sections, with the 12th stating that it takes effect immediately, so effective on July 17, 2024. And the key provisions of the act address ownership of pore space, the permitting and operation of injection and storage facilities, and the liability and long-term responsibility for stored CO2. So let's start with pore space ownership. So pore space refers to the empty spaces or cavities within underground rock layers that can be used to store carbon dioxide or other substances. According to the Act, the owner of the surface land, called the surface property interest owner, also owns the pore space beneath that land. Under common law, surface owners own everything from the sky down to the center of the earth. And even if they have separated the mineral rights from the land, they still keep ownership of the pore space, unless stated otherwise. Pennsylvania's approach is no different. Essentially, if you own the land on the surface, you automatically own the pore space on the ground. And this applies to all land and waters within Pennsylvania. The Act specifies that when surface land is sold or transferred, the pore space rights are automatically included unless they have already been separated through a legal agreement. However, if someone sells or transfers rights to minerals such as coal, oil, or gas, those agreements do not include the pore space unless it is explicitly stated. And when transferring pore space rights, the legal document must clearly explain what rights the new owner has to use the surface land above the pore space. The pore space owner can only use the surface as explicitly outlined in the legal agreement. And since this law went into effect, any transfer of pore space rights must include a clear description of the location of the pore space being transferred. This includes a meth and bounds description, which outlines the surface boundaries above the pore space, and it must identify the specific subsurface layers or formations involved. If the document only describes the surface without mentioning depth, it is assumed the pore space rights cover all depths unless stated otherwise. The Act also addresses how pore space ownership interacts with other property rights. Excuse me. It establishes that mineral rights are dominant. So this means that if there is a conflict between using pore space and extracting minerals, the mineral rights take priority. This gives mineral rights owners the ability to use both the surface and subsurface as needed for resource extraction, even if someone else owns the pore space. Additionally, the Act protects any contracts or leases for pore space that were already in place before the law took effect. This agreement remained valid regardless of whether they were made with a subsurface owner or a prior property owner. Now, there are some public land considerations. Before leasing or transferring pore space under public land, the government must provide public notice, hold a hearing, and allow people to share their opinions before making any decisions. Now this section addresses situations where pore space is owned by multiple people. CCS project developers must negotiate with the pore space owners for permission to use the space. If they cannot reach an agreement with all owners, they are still allowed to proceed if they have agreements from at least 60 to 75% of the owners. They can apply for a collective storage order from the Environmental Hearing Board as long as they have made a genuine effort to contact all the owners. If some pore space owners cannot be found or their contact details are unknown, the law assumes they have agreed to the use of their pore space, again, as long as the developer has made the necessary good faith efforts to reach out to all owners. Now, in cases where there is disagreement about using the pore space for CO2 storage, meaning not all the owners agree, the Secretary of the Environmental Hearing Board has authority to step in. And the law gives the Secretary the authority to include those who don't consent in the agreement. And this is what we call forced pooling. And the law guarantees that non-consenting pore owners receive compensation, which will be clearly stated in the collective storage order. And this compensation should reflect the fair market value of the pore space being used. Additionally, the law makes it clear that a collective storage order does not automatically grant CCS project developers the right to access or use the surface land above the pore space. If they need to use the surface, they must negotiate a separate agreement for that. Now, some restrictions apply. However, the Environmental Hearing Board cannot approve a collective storage order for specific types of land unless the pore space owner has voluntarily agreed to lease or transfer it. And this includes government-owned land, land protected under Pennsylvania's Conservation and Preservation Easements Act, land owned by charitable organizations dedicated to conservation, agriculture, recreation, or preserving natural, historical, or cultural features, and land designated as open space under Pennsylvania's Open Space Act. Now, the law also requires CCS project developers to review potential seismic activity as part of obtaining a UIC Class 6 permit. They are required to conduct seismic surveys around the proposed storage site to assess geological stability and identify potential risk. Developers also required to set up a seismic monitoring system near the storage site to track the presence, magnitude, and location of any seismic activity. So this data helps evaluate the risk of induced seismicity, which are man-made earthquakes caused by injected fluids into the ground. And if monitoring detects seismic activity beyond acceptable levels, the developer must notify the Secretary and take action to mitigate the issue. In certain cases, if a risk analysis shows that permanent seismic monitoring is not needed for a project, the Secretary may allow the developer to stop local monitoring and instead rely on national or state systems for long-term observation. Now, for a project to move forward, project developers need to get a UIC Class 6 permit, like I said, and make sure they follow all the required regulations at both the state and federal levels. The law requires that the Environmental Quality Board set up regulations and permitting criteria to make sure these projects protect natural resources, public health, and safety. The rules will also require assessments of how the projects affect the surrounding communities. It specifies that if the project affects an environmental justice area, which is an area described, that is already dealing with higher pollution levels and has vulnerable populations, then extra steps will be needed. This includes conducting more in-depth assessment, ensuring the public has a chance to weigh in, and providing clear reporting. What is interesting in this section is that the law gives the DEP the authority to add conditions to or deny permits based on these regulations. So this opens the door for DEP to apply to the EPA for primacy to issue Class 6 UIC permits. As I mentioned earlier, Pennsylvania does not currently have EPA-approved authority to manage UIC wells permits. So the EPA is responsible for overseeing the program in the state and issuing permits directly. At the DEP Oil and Gas Technical Advisory Board meeting that was held in March 2023, the board talked about Pennsylvania's approach to carbon capture and storage, and it was mentioned that DEP is considering pursuing primacy of such wells. But that's still where things stand today. So until Pennsylvania gets primacy, the EPA will continue issuing UIC injection permits in the state. And the law also allows DEP to charge fees for permits or ongoing project management to help fund the oversight and enforcement of carbon sequestration activities. Additionally, the law also provides that carbon sequestration projects must be planned so they don't interfere with extracting valuable minerals. The goal is to ensure that the CO2 injected into the storage area do not impact the ability to produce these minerals. So if the storage site does contain valuable minerals, the project can only move forward if the DEP is confident it won't harm these resources. So the project developer is required to check if there are any commercially valuable minerals in the area, identify the subsurface property owners, and notify them in writing. If a mineral owner thinks the project could affect their ability to extract those resources, they can object to the DEP. So when carbon dioxide or other substances are injected into a storage facility, the project developer is considered the owner of the injected material and will be responsible for all rights, benefits, burdens, and liabilities associated with it. Additionally, the law clarifies that the pore space owner should not be held responsible for the effects of the CO2 injection or any other substances used in the process, just because they own those property rights. So the law makes it clear that liability does not fall on them simply due to their property interests. Now, if someone wants to file a damage claim because of CO2 injection or its movement in a sequestration project, they can only do so if they can prove the project developer was not careful. They need to show that the injection or migration happened without reasonable care and caused harm to a person, animal, or property. As long as the project is following the rules and has a valid UIC Class 6 permit, the developer is protected unless they can prove, unless the claimant can prove negligence. Now, if a surface property interest owner, subsurface property owner, or lessee faces injury, damage, or loss in property because of CO2 injection or its movement, they can take legal action against the project developer. They can seek various forms of compensation, such as general and special damages, punitive damages, attorney fees, or even an injunction order to stop the activities. So now the law sets up the carbon dioxide storage facility fund within the state treasury to support carbon sequestration projects, along with a restricted account within that fund. So the fund will help cover DEP's cost for processing permit applications, regulating storage facilities during construction, operation, and pre-closure, and determining the amount of storage capacity needed, while the restricted account is meant for costs associated with long-term monitoring and management of a storage facility after it has closed and the project is completed. So the law requires CCS project developers to pay a fee for each ton of CO2 they inject for storage. The Environmental Quality Board will set the fee based on the anticipated cost the DEP will face for regulating the project and monitoring it long-term. The fee schedule will be made public through the Pennsylvania Bulletin. Half of the fees will go into the fund, while the other half will be set aside in the restricted account for long-term project management. And any penalties for violations of this act, along with money the DEP receives from financial responsibility mechanisms, will all go into the fund. Now, upon completion of a carbon dioxide storage project, the operating company must formally request a certificate of project completion from DEP. However, the certificate will not be issued until at least 10 years and potentially up to 50 years have passed since the last CO2 injection. So this extended time frame is to make sure the project is truly safe and stable in the long run. When the certificate is issued, the company essentially gives up ownership of the stored carbon dioxide and the equipment used to inject it to the Commonwealth. This transfer occurs without any compensation to the company. Concurrently, the Commonwealth assumes responsibility and liability for the stored CO2. Furthermore, the Commonwealth is responsible for the long-term monitoring and management of the stored CO2 until the federal government comes up with a system for overseeing such activities nationwide. However, the Commonwealth may not be held responsible if the company violated any rules or regulations during the project and the legal time for taking action against them has not passed. Also, if the company's actions caused carbon dioxide to leak and threaten drinking water, the Commonwealth might not be responsible. And finally, if the funds set aside to deal with potential problems after the project closes are insufficient, the Commonwealth may not be fully liable for any issues that arise in the future. Now, before we wrap up this webinar, I want to quickly give you a snapshot of what other states are doing when it comes to carbon capture and storage. In the first half of 2024, a handful of states made significant moves to introduce or expand carbon capture and storage laws. Just like Pennsylvania, Alaska, Alabama, Colorado, and Illinois passed some important new CCS laws. So Alaska governors signed House Bill 50 into law in October 2024. It sets up a process for transferring pore space ownership and ensure long-term monitoring is funded. It also provides that after 50 years, the state will take on responsibility for the CCS project. The law also makes public lands available for future CCS projects. In May 2024, Colorado expanded its CCS framework, clarifying pore space ownership. Operators can now combine ownership interest across properties, provided most owners agree. It also introduces fees for oversight and provides support for local governments to help with seeding. And the state is moving to take over permitting from the EPA. Illinois also passed a comprehensive CCS legislation in July 2024, defining pore space ownership and setting up a process for combining ownership across properties. And finally, Alabama signed House Bill 327 into law in May 2024. It requires landowners to give their consent for pore space rights and creates a fund to support regulation. The law also includes rules for CCS near existing operations and opens up public land for leasing. Now looking closer to Pennsylvania, New Jersey has not introduced any CCS-specific legislation, while New York, although lacking formal legislation, supports the use of CCS technology for certain industrial applications. Maryland also has no dedicated CCS laws, but relies on CCS as part of its climate action plan to meet greenhouse gas reduction goals. Similarly, Virginia has not passed any CCS legislation, but promotes research and development of carbon capture, utilization, and storage technologies. And Delaware has not taken legislative action on CCS either. West Virginia, however, has taken significant steps. The state passed a carbon dioxide sequestration bill back in 2009 and recently hit a major milestone. On January 17, 2025, it received EPA approval to oversee and manage permits for Class 6 wells, which is an essential step for advancing CCS projects. Additionally, if you look at the slide here showing states with current primacy application for the UIC well program, Colorado, I mean, you can see Colorado and Alabama also actively working on securing this authority. And going back to the other slide, if you're interested in staying up to date on state actions around carbon capture and storage legislation, you can just check out the CCUS State Legislative Tracker. It was created by the law firm Arnold & Porter and is available to the public through the Columbia Climate School's Sabin Center for Climate Change Law. And I'm sorry, I forgot to add a link to the tracker on that slide, but we'll do so when we post it on the website. So that brings us to the end of the webinar. Thanks so much for tuning in.
So thank you so much for everyone for joining us. We encourage you to join us again next month on February 28th for pesticide drift. And then we've got more programming coming up in March and so on and so forth. So thanks everyone. Have a great weekend and thanks for joining us. Bye all.